Good afternoon. We have a quorum. The meeting is now called to order. Let us invite the officials into the room. Once again, may I welcome the government officials. Now, since our last meeting, we have received 3 written submissions from the trade and also the suppliers with regard to these views, and also the written views of some other groups and also members of this council. Would the administration respond to these views? Thank you, Chairman. Shall I start with the submissions? We have received altogether 3 submissions. One is from ExxonMobil, and the other is from a professor, and the third is from the Toys Council. And in fact, the one by ExxonMobil and also the professor are the same. Their view is that the regulation of the 6 plaster sizes with regard to these, they said that different studies show that they were not as toxic as we believe, and according to certain studies, some of the materials even do not have a harmful effect on human beings. But as we have said, when the European Union and the United States, in setting the rules, they know that the 6 plaster sizes can be divided into 2 groups, and for one group the test results are conclusive, whereas the test results of the other group are not so decisive. Therefore, the regulation of the second group is less strict, and only the part that can be put into the mouth of the babies or children will be regulated for the second group. If you look at the regulatory framework, you can see that we are following the European Union and US approach. Since the test results are different between the 2 groups, the standard of regulation between the 2 groups are also different. If you just look at the bill itself, you may not be able to see the framework. As for the view of the Toys Council, there are certain textual issues. If I may speak on the framework first before I turn to the textual matters. Give me a second, please. At our previous meeting, 2 types of questions were raised. First, concerning the Chinese expression 长牙, and how should it be rendered in Chinese. There was a suggestion to use the term 出牙, but it was considered to be too colloquial. And we have replied to the Council with regard to the term 長牙 means growth of teeth. But if members have different understanding and is concerned about a misunderstanding, we prefer to use a longer phrase 牙齒生長, which is clearer. And there is also another issue in respect of whether food and pharmaceutical products are excluded. We've already said that food and pharmaceutical products are excluded because they are regulated by other laws. But children products are to facilitate sucking and teething, so on and so forth, that may therefore cover food and pharmaceutical products. We believe we can use an express provision to exclude that, and we will move a CSA in this regard. As for the third point, in respect of the proposed regulatory framework, this is also a textual matter. If members may refer to the annex on the regulatory framework. Now, the framework doesn't represent the exact wording of the subsidiary legislation, but the framework does provide a broad outline of what we intend to do. And we will also take up the question of whether the packaging is included. If you may refer to the annex, we will spell out 6 types of phthalates that will be controlled. They are divided into 2 groups. Group 1 is DHP, DBP, and BBP, and Group 2 covers DINP, DIDP, and DNOP. As for the second group of phthalates, the group cover the phthalates mentioned in the submission. As for the scope, the regulatory framework covers toys. In fact, there is a definition in the ordinance, and we will spell it out. Only A is covered, that is the toy itself, and B is not included, or B is excluded. B is the packaging. The scope also covers products under Schedule 2. There are 12 toys or 12 products under Schedule 2 which are under control already. We are to include Schedule 2 products that intend to facilitate the feeding, hygiene, relaxation, sleep, sucking, and teething of a child. It's not everything in the in Schedule 2, such as other toys for, say, helping children to walk. Part 3, anything that is not in Schedule 2, but products that facilitates feeding, hygiene, relaxation, sleep, sucking, or teething of a child under the age of 4. If they have any plasticized materials, they will be covered by the law. These 3 categories will be included, but their packaging will not be included. The control is divided in 2 groups. Group 1 phthalates. A toy. If a toy contains any plasticized materials, then the phthalates should not exceed the total weight by 0.1%. That's for toys with Group 1 phthalates. As for Group 2 phthalates, that is to be put into the mouth. If the whole piece of toy can be put entirely into the mouth, then the percentage of Group 2 phthalates should not exceed 0.1% of the total weight of all the plasticized materials in the toy. But if only part of the toy can be put in the mouth only, then it will be the parts of a toy that can be placed into the mouth. That's the regulation on toys. As for children products, those that assist sucking, feeding, so on and so forth, the regulation is the same as toys. The regulation is divided into Group 1 and Group 2, and as for Group 2 phthalates, the product has to be is used to be put into the mouth. As for the 3 submissions, one is by the Toys Council. The Toys Council says something on how the subsidization should be worded. It doesn't want the word all and also the word total weight. In doing the calculation, there is no difference between Hong Kong and other parts of the world. The question is whether the wording is clear or not. We believe that that's all about the denominator, and if, we believe that the total weight of the plasticized materials is clearer than they suggest. That's not a matter of calculation, but how the text is worded. The denominator should be the total weight of all the plasticized materials. The second point by the Toys Council is this. Now we have a phrase be placed in the mouth. They want a clearer wording. But if you refer to the framework in the annex to the paper I mentioned earlier, we have already provided the wording. If you may refer to para 5 and para 4 and para 5, what is meant by be placed in the mouth.
而呢個寫法呢
The wording is in fact adopted from European Union, the European Union and the US. The toy can be brought to the child's mouth and kept there so that it can be sucked or chewed. The third point by the Toys Council is about the inaccessible parts of the toys or child care articles. Say, according to the framework, we mean that can be brought to the child's mouth and kept there in a reasonable manner that can be brought into the mouth, brought to the child's mouth. That's about a close contact with the child. We understand the view of the Toys Council, and when we draw up the regulation, we will try to reflect their view. The fourth point is on packaging material.
We will make it clear for the three items the amount of plasticides exclude the material used in packaging. Toys Council also mentions about the respective testing methods of EU and US, whether it exceeds 0.1 and the methods of extraction. That is paragraph 4 of their paper. We're asked whether these methods are adopted. We don't have a particular method in mind. If government, chemist, or approved laboratories are used, and if the sector uses approved laboratories, these laboratories will use the most prevalent testing method. So it's not necessary for us to explicitly state whether we're using the US or the EU method. I'd like to hear views from members before we have a discussion. I declare that I am a director and shareholder of a number of toy factories. Any other declarations? No? First, let's deal with the term 長牙. Last time that different views were given from members, the administration has responded. They came up with a different term, 牙齒生長, growth of teeth. Mr. Low, Low-Ai-Kok. In the last meeting, I looked up the internet and I saw from Baidu, a mainland site, they used the term 出牙, teething in English, and I checked the D.H. website, their oral hygiene education unit. And there is an article, and there is a section about teething of children, and they also use the term 出牙. They talk about the front teeth of children and molars when they will start to emerge, etc. So you see the term 出牙 is used in Hong Kong and the mainland as well. It's rather common. And the government, that is the DFH, uses this term. This may not be significant, but if you use the word 出牙, then the meaning is apparent. In the DFH website, they talk about discomfort of teething. Then they use teething rings to soothe the discomfort. So we're talking about soothers used to soothe discomfort from teething. I think the term 出牙 is easily understood. So I don't really understand why there is so much resistance with adopting the term 出牙. Ms. Sidho, sorry about opening this can of worm. I will accept the administration's proposal of 牙齒生長, but whether it is textual in text or spoken, we don't use the word 長牙. And if you use the term 出牙, it is understood in text as well. Well, whether it is 長牙, 出牙, or 牙齒生長, they mean the same thing, and there is little difference. And if you talk about the emergence of teeth, you talk about that moment when a tooth emerges. Even if the term 長牙 is used, I don't think it will render the provision incomprehensible. Whether it is 長牙 or 牙齒生長, there is little difference. Perhaps we should leave it unchanged. Free comments made. Let me hear perhaps more from members. Mr. Wang Ting Kwong. I don't have a particular view whether it's 出牙 or 長牙. Well, as long as there's some kind of teeth emergence, the word 牙 appears, that will do. If there is no particular view and members think that all three versions are acceptable. Ms. Ho, I do think that the term 長牙 is not commonly used in Hong Kong. No, I just said that all three are acceptable, and it seems that 出牙 is easier to understand. For 牙齒生長, I think it's rather clumsy. If we use the word 出牙, I think the government will have to communicate among its departments. Otherwise, there'll be different versions. 出牙長牙, 牙齒生長. And that will be inconsistent. Alice. Well, of course, the English version is acceptable. I think the problem lies in the Chinese term. Different people may see differently when it comes to the two terms 長牙 or 出牙, and the middle ground may be 牙齒生長. Perhaps I will see if the Lord Draftsman has anything to say when it comes to the Chinese text. Sorry, the speaker's off mic. We have a Chinese saying using both 長 and 出 in 狗口長不出象牙. Elephant's teeth can't grow in a dog's mouth. Or do we need to get some experts to explore and explain further? Well, if you think that 出牙 is acceptable, and if you think that 牙齒生長 is acceptable, perhaps we will simply adopt it instead of getting bogged down on the different terms. Mr. Wycock, I think the best approach is the term that's been used by government departments. The D of H has a website targeting oral hygiene, and they use the term 出牙. And it's not just about the actual emergence of the teeth. Talk about front teeth 6 to 9 months, and then incisors, and then molars 22 to 23 months, and we're talking about the relevant item used by children under the age of 4. I think it would be safe to adopt the terms used in the D of H website. I think we have a consensus on the term 出牙. Please deal with it. Well, we'll see if the Lord Draftsman has anything to say. In jurisprudence, the most important thing is to ensure that there is no discrepancies in the meaning between the Chinese and the English text. In the dictionary, one single word may have different meanings. And as to which term to use in context, there may be difference in meaning, and we have considered whether to use 長牙 or 出牙. We think that the meaning of 長牙 is very clear, and there is no difference in meaning with the English text. But if the word 出牙 is used, there may be the meaning may be slightly vague, because it may mean the actual emergence of a tooth. We have considered other terms that may express it more clearly. And we consider the term 牙齒生長, which is plain, because there won't be any concern about difference in meaning between the Chinese and the English texts. Members have made themselves very clear and don't want to spend too much time on the terms 長牙 or 出牙. This is just for information. If you talk about English and Chinese texts, but in Baidu, the translation of 出牙 is teething. And I have an electronic dictionary with me. if you look up the term teething, it says 出牙 in brackets deciduous teeth. So there is an equivalence on translation sites. Well, I will ask the law draftsmen to consider it. Yes, please do, and come back to us with the final version. Mr. Wong Ting Kwong. Chut nga is colloquial. It's more Cantonese. But I think the point is not whether to choose between chut nga or zheng nga. Law draftsman, could you please look it up? What is the term used in existing provisions? Because we want to achieve consistency. If a different term is used in existing provisions and we use the term chut nga this time, then it may give rise to blurring of meanings, and thereby causing difficulties in law enforcement, and it may be subject to challenges. Well, here we are only talking about the bill related to plasticizers, and it relates to children's products. The ordinance itself is in place for a very long time. I'm a manufacturer. To me, I think there is a little contention of the difference between the terms 整牙 and 出牙. Alice, perhaps you will talk to some Chinese experts. Experts on Chinese, and then come back to us with an answer. Let's stop here. Next, if plasticizers are in an inaccessible part, then it should not be included. And as to how it's drafted, I think clarity is very important. And packaging. It's not catered for in the principal legislation, but in the subsidiary legislation. Can it be made clear in the principal legislation and not the subsidiary legislation, Alice? The principal legislation regulates on the different levels for different items. Say, for example, if in the future there is a regulation on packaging of a toy, then we will still proceed under the same ordinance but a different subsidiary legislation. The coverage of the principal legislation should include this. But when it comes to the individual subsidiary legislation, it depends on the specific area that is under regulation. Say, for example, in the regulation, we will make it clear in the framework the exclusion of packaging.
You're welcome.
And you can also see the scope of the subsidiary regulation. In fact, the scope doesn't include everything under Schedule 2. We spell out in the regulation which part of Schedule 2 is covered. So the regulation provides the flexibility on the area to be regulated. At present, the ordinance covers both toys and their packaging. This has never been changed. The regulation is to spell out the specific area to be covered. Concerning the clarity of the subsidiary legislation, we have already highlighted that, highlighted the area to be covered in the regulation. You know our purpose. And when you come to the subsidiary legislations, you have a chance to look into them. I think the trade and also members have given their views. We are not dealing with the subsidiary legislation. But when it comes to the subsidiary legislation, we are afraid that it will be missed. If you give the undertaking that you will spell out it very clearly in subsidiary legislation to exclude the packaging, then would that be okay? Oh, okay. Then what about the part that is not accessible? Now we have look at this view. The part that is not accessible should not be regulated. And we will spell out this in the regulation. What is meant by inaccessible parts? There are all sorts of toys and children products in all shapes and sizes. Basically, we are of the view that inaccessible parts will not be included. So you will spell it out clearly in the regulation. Yes, indeed. But we have yet to find out a way to write it. As for packaging, we've already incorporated excluding packaging. We've already included. We have already excluded that in the framework. What about testing methods? Now there are two approaches. Or two laws, one one for the European Union, the other for the US. If you look into the details, they are different. If you just single out a particular bit here or there, it will cause a lot of controversies. Now we set out the standard 0.1%, but the testing method, as far as the testing method is concerned, the one in Europe is different from that of the US, but they yield the same results. We therefore do not need to put it down in the law with regard to the testing methods. Now when the trade takes a toy to conduct a test, then the test will have to be done in an approved laboratory, and the laboratory will use a method that can be recognized by different countries. As for the test, it's different with regard to the test of different parts and the whole. Say, for example, tension. That is the difference between Europe and the US. Say, for example, another test. Then there may be different tests for the same criterion. If they fulfill the U.S. standards, all the U.S. standards, they will say that's okay. But if you just pick out a particular aspect of the test, then it will only suit U.S. but not the European Union. So how are you going to deal with that situation? Well, we are just on the issue of plasticized materials. Now, within the regulation, there may be other things, but as far as plasticized material is concerned, we do not specify the testing method. I think you need to spell this out clearly. You just use a part of the ordinance to compare with the whole ordinance. Is it fair? Well, I think as for the European Union or the US, they are not just limited to the EN or ASTM. in comparison with other things like attention mentioned by the chairman, they have the ASPN. They have different regulation for the phthalates. I hope that the regulation will not lead to any controversy, and also the test standard will not cause any controversy. Let's go to the clause-by-clause study of the bill, and we are on page 8 or clause 9 is about taking the tests to the laboratory to do testing. Under 9.2 or section 9.2 and 9.3, the children product will be replaced by Schedule 2 product. Schedule 2 products, we used to call them toys. We used to call them children's products, but now we call them Schedule 2 products. And we also at C, we extend the scope to cover products for children below 4 to facilitate sucking, feeding, so on and so forth. We therefore have to add C. Other amendments are just textual, and they do not affect the original meaning. Now they switch from children's product to Schedule 2 product and adding a provision, any other children's product. This is done under other sections as well. Any questions? Section 11, prohibition notice. Like the previous one, under B, children's product is replaced by Schedule 2 product, and a subclause C or subsection C is added to include any other children's product. Other amendments are technical. Okay. Section 12, recall notice. Just like the previous one, children's product replaced by Schedule 2 product, and adding a C limb to cover any other children's product, and there are certain textual amendments. Is it okay? Okay. Section 13. Section 13 deals with other powers of the Commissioner. Like the previous amendments, children's product is replaced by Schedule 2 product, and also subsection C is added to subsection C is added to the relevant subsections to take care of any other children's product, and there are textual amendments. And there is an amendment to 13.3. The Commissioner may require a person who to issue a warning notice. We add as specified by the Commissioner. Others are just textual amendments. Concerning section 13, I want to go back to page 3. Concerning the Commissioner and Deputy Commissioner, we gave certain comments. In your reply, Alice, you didn't respond to this. Since we touch upon the term commissioner again, I therefore want to deal with that. In fact, a member asked whether the practice is common, and that is in the provision commissioner, only commissioner is mentioned, but in the interpretation, commissioner means deputy commissioner or assistant commissioner. This arrangement is not uncommon. In other ordinances, a director may just be mentioned in the provisions of the ordinance, but in the interpretation section, department director also means deputy director, assistant director. This is a common practice and is also clear in the law, or in terms of law drafting. Concerning interpretation of commissioner, in page 1 of the English version, this part will be maintained. Well, in fact, our present amendment in under section 13 doesn't affect that part of the interpretation. Any comments from members concerning section 13? If not, then section 14 is about appeal to appeal board. It is an appeal against a decision or action of the commissioner. Subsections 1 and 2 spells out the circumstances of appeal and the time limit for making the appeal. Under subsection 4, an appeal under this section against a decision should include a decision or action of the commissioner for the avoidance of doubt. It has not made any change to our policy intent. It is just to tidy up the provision. Okay, then, no question. We move on to page 14, section 24. Just a simple amendment. Children's products will be replaced by Schedule 2 products. And nothing else. Okay? Yes, then move on. Section 27. They are textual amendments. Children's product standard replaced by toy standard or Schedule 2 product standard with an additional safety standard. It doesn't change our policy intent. It is just to widen the scope of application. Okay, any problem? If not, then section 35, regulations. It spells out the circumstances under which what kind of regulations can be enacted by the Secretary. We've tidied up this part. Under 35(1), A, B, and D, and E, have already included the existing 35(1)A to E. We just update the children product part. Well, as for 35(1)E, we have never invoked that provision, and we propose to repeal it. The new 35(1)E is a common provision in other ordinances in respect of the making of regulations, and we put it in under 35(1)(e) as well. As for maximum fine, we simplified it to $500,000, and maximum imprisonment is 2 years. That is actually the same.
In relation to D, well, it doesn't cover possession. For E, 3, bracket 3, it seems a common practice to talk about the different levels, a level 1 fine, level 2 fines, and something like that. Is it the case that $500,000 exceed all the different penalty levels? That's why it uses a monetary term. No, it's not a standard. They talk about different levels of penalty. That is a common practice nowadays. And if they use a different level instead of the actual monetary term, then it doesn't involve so many legislative amendments. Mr. Sin is right. $500,000 exceeds all the levels. What about the term of imprisonment? The imprisonment of 2 years. That is the maximum imprisonment. Do we have a corresponding penalty level? No, only for fine. No, it's not my suggestion that there should be. So it doesn't cover possession. No, it's supply. It involves supply only. Let's continue. This is the last part. Changes to the schedule. Well, Schedule 2 is no longer called Children's Product Standard. It's called Schedule 2 Product Standards. Please continue. That is the end. Do we have to go through the English version page by page, or? Well, we have completed this, and the administration will submit committee stage amendments for members' consideration. If there are no questions raised, we're still waiting for responses from the administration of questions asked. So, members, would you like another meeting? Or circulation of the written response is fine by you? Well, when do you think you'll be able to give us that? Let's try this week or the next. There is a CSA on food and pharmaceutical product, and the term related to teething, we will get back to you. As soon as we receive the document, we will give them to members, and then we would decide whether we need another meeting, because after the scrutiny we have to revert to the LegCo for second reading. We have to make arrangement for the date. If we think there is no problem with your written reply, when do you think you will submit it to the council for second reading? As long as it's before the end of the year, before the end of December. Before the end of December. Then make it middle of December, because we have a recess for over Christmas, before the Christmas holiday. So it's the first half of December, because we won't have much time if, well, after the 15th. Well, either the 4th or the 11th. Before that, we have to revert to the House Committee. Yes, we will aim at that date. If there are no problems, when do you reckon the effective date will be? Before middle of 2014. We have to have the bill endorsed, and then we will introduce the subsidiary legislation. It's 28 plus 21. In relation to the effective date, I'd like you to do something more. You expect manufacturers to make changes at the middle of the year. It may cause interruption. What about the end of the year or during the trough period of the sector to minimize disturbance? You don't have to give me an answer now. It would be better if you make a decision after consulting the trade. Do you agree, Mr. Morningclaw? Chairman, what I have in mind is that the material used in the trade to manufacture toys are carefully selected. There is a very small local market. Our main markets are overseas ones. And these requirements are in place in overseas countries. My concern is that if we have the legislation in place, there may be an adjustment period. There may need to be an adjustment period. And Chairman, I believe your factories have adopted international requirements. Otherwise, the products shipped overseas will not be imported. So the actual effective date is not significant. As far as I understand, the new legislative requirements are in place for EU and US. Most of our products are for US and Europe, so for us it's not a big problem. But there may be manufacturers that aim at the local market. For them, they may be affected. Let's maybe do something more. I think it's only a matter of difference of a few months. I don't think there will be a strong objection from the trade once a date is proposed. There are 4 of the 6 types of plasticizers are rarely used. DINP and DIDP are still used. So I believe that the impact will not be huge. But on the safe side, I would like to ask the administration to do a little bit more. Perhaps 1st of June or 1st of July. I don't think there is problem for suppliers of raw materials, because as long as there is sufficient time given to them, that will do. But we don't want the change to result in a halt of the production process of manufacturers. Well, if it can be effective on the 1st of July next year, that would be good. Of course, on one hand, we would like to implement consumer protection as soon as possible in this regard. Before we implement it, we will consult the trade. We don't want to launch anything that will affect the trade without consulting them. And as to how much they need to make preparations and the cushion period, we will adopt that as far as possible. We've been consulting the trade all along, and we will do so. We will continue to do so. Mr. Lo Wai Kok, just ask for information. Chat Nga is the dental hospital of the Hong Kong U. They use the word Chat Nga. I think it's quite authoritative because it's the Hong Kong U. Well, we're glad to have an expert on teeth in this committee. If there are no other business, meeting adjourned. Thank you.